What steps should I take if I've been injured in an auto accident in Florida? Not long ago, I had a client walk into my office, and he thought his car accident case was hopeless. The insurance company had refused to make any offer and blamed him for the accident. Another PI firm had even discharged him as a client, and he was completely helpless and still in a lot of pain. By the time we finished working together, we got him the full available insurance policy for $250,000. The difference? He learned what I'm about to share with you. 12 critical steps that most injured people in Florida don't know about injury claims. Insurance companies, they have playbooks designed to minimize what they pay you, and they're counting on you to make mistakes. In the next few minutes, I'm going to share with you the exact roadmap that has helped my clients recover millions of dollars. By the end of this video, you'll know exactly what to do if you're ever injured in an auto accident in Florida, and how to avoid the costly mistakes that can destroy your case before it even begins. Let's begin with the moment after the accident. Get medical attention immediately, even if you feel fine. Hi, I'm Pablo Tamayo, and I've been an attorney practicing law in the state of Florida for over 18 years. And if you've been injured in an auto accident in Florida, the single most important thing that you can do is to get medical attention right away. I know what you're thinking, but I feel fine. I don't think I'm hurt. Well, let me tell you something. I've learned from representing hundreds of clients over the years. Feeling fine immediately after the accident means absolutely nothing when it comes to your actual injuries. Your body produces adrenaline and endorphins during traumatic events like car accidents. Those natural chemicals can completely mask the pain and injury symptoms for hours and sometimes even days. I've had clients walk away from accidents feeling perfectly normal, only to wake up the next morning unable to move their neck or experiencing severe headaches or extreme pain in their lower back. Here's a critical part that most people don't know. Under Florida law, you have only 14 days from the date of your accident to seek medical treatment if you want your personal injury protection, also known as PIP, to cover your medical expenses. If you miss that 14-day window, you could lose thousands of dollars in coverage that you'd otherwise pay for. Florida Statute 627.736 is a very specific requirement, and insurance companies will use any excuse to deny your claim. But beyond the insurance requirements, getting immediate medical attention creates crucial documentation that connects your injuries to the accident. Without this immediate medical link, insurance companies and opposing attorneys will argue that your injuries came from somewhere else. Maybe you hurt your back lifting something heavy, or you slept the wrong way and now you have neck pain. Number 2, don't downplay your symptoms to medical providers. When you see that first doctor, or if you've gone to the hospital and you're in the emergency room, you need to be completely honest about every symptom that you're experiencing, no matter how minor it seems at the time. That slight headache, the mild neck stiffness, the lower back discomfort. Report all of it. Don't be a hero, and don't minimize what you're feeling. I've seen too many cases where clients told the doctors they were fine or just a little sore because they didn't want to seem like they were complaining. Then weeks later, when their pain got worse and they needed extensive treatment, the insurance company pointed to that first medical record and said, "You see, they weren't really hurt." Medical providers need to know about every symptom because some injuries don't show their full extent immediately. A mild headache after an accident could be that of a beginning of a concussion. Slight neck stiffness could be whiplash that develops into chronic pain. Lower back discomfort might be a herniated disc that takes several weeks, months to manifest. Document everything with your healthcare providers. If you're experiencing trouble sleeping, difficulty concentrating, mood changes, or any other symptoms that seem related to the accident, trouble doing your job, performing your job duties, make sure they're noted in your medical records. Or make sure that you tell your doctors at your visits exactly what's bothering you and what you're restricted in doing. These seemingly minor symptoms can be signs of traumatic brain injury or other injuries, which is far more common in auto accidents than most people realize. Number 3, follow up your treatment plan provided by your doctors. Once you start receiving medical treatment, following your doctor's orders isn't just important for your health. It's actually crucial for protecting your legal rights. Why is that? Well, insurance companies and defense attorneys will scrutinize your medical records, looking for any gaps in treatment or missed appointments that they can use against you to minimize your injuries. If your doctor refers you to physical therapy, you should follow your doctor's orders. If they recommend follow-up appointments, you should keep those appointments. If they prescribe medication, take it as directed. I've seen cases where clients missed a few physical therapy sessions or they delayed a follow-up appointment for months, and the insurance company invariably argued that their injuries couldn't be that serious if they weren't following their treatment plan. But here's what's equally important. If a treatment isn't working or if you're experiencing new symptoms, communicate that to your healthcare providers immediately. Don't suffer in silence, thinking you're supposed to just tough it out. Again, don't be a hero. Your medical records need to accurately reflect the ongoing impact of your injuries. It might be a good idea to keep detailed records of every medical appointment, every treatment session, and every prescription that you've been provided by your provider. Keep copies of all your medical records, bills, and any other correspondence with healthcare providers. This documentation becomes crucial in all of your cases. Number 4, understand Florida's no-fault system and when you can step outside it. So Florida is what's called a no-fault state, which means your own insurance company pays for your medical expenses initially, regardless of who caused the accident. Your personal injury protection, your PIP coverage, will pay up to your policy limits, usually $10,000, for medical expenses and even lost wages. But here's what many people don't understand. Being in a no-fault state doesn't mean you can't sue the person who caused your injuries. If your injuries meet what Florida law calls the serious injury threshold, you can step outside the no-fault system and pursue a claim against the at-fault driver for pain and suffering, lost wages beyond what PIP covers, and other damages, past and future medical bills. Florida Statute 627.737 defines serious injury as permanent injury within a reasonable degree of medical probability, significant and permanent loss of an important bodily function, permanent injury within a reasonable degree of medical probability, and significant and permanent scarring or disfigurement or death. The key word here is permanent. This doesn't mean your injury has to be permanent from day one. It means that your doctors determine there's a reasonable probability that your injury will have permanent effects throughout your lifetime. Many injuries that seem minor initially can have permanent consequences. Whiplash can lead to chronic neck pain. Concussions can cause lasting cognitive issues. Herniated discs can require surgery or ongoing problems, pain, discomfort, stiffness, restrictions to your everyday life. Number 5, be extremely careful when talking to insurance adjusters. After you report your accident, you'll likely receive calls from insurance adjusters, both your own company and the other driver's company. While your own insurance company has a legal duty to handle your claim in good faith, the other driver's insurance company has no such obligation to you. Their job is to pay out as little as possible and to protect the rights of the other driver. Now, the insurance adjusters are actually trained professionals who know exactly what to say and what to do to try and minimize your claim. They might seem friendly and concerned about your well-being, and they may be, but at the end of the day, remember this: they're not your friends. They're working to protect their company's bottom line. One of the most common tactics that insurance companies deploy is to call you within the first few days after the accident, when you're still shaken up and your injuries might not have fully developed, and you're worried about issues like getting your car back, being able to drive yourself to work, the everyday stuff that normal individuals worry about. Now, the insurance adjuster will call you and they may ask you to give a recorded statement about what happened and how you're feeling. Now, know this: you are not required to give a recorded statement to the other driver's insurance company, and I would strongly advise against it. Why? Because at that point, you might not know the full extent of your injuries. You might say something like, "Oh, I'm feeling okay," or "I think I'll be okay, I think I'll be fine," and try and minimize the effects of the incident just by nature. But then weeks later, your pain gets worse and you're making a claim for that injury or those injuries that you're dealing with and treating for. And they'll play back that recording and they'll argue, "You weren't really that injured. Remember, you said you felt fine. You said you felt okay for the most part." So at the end of the day, providing a recorded statement to the other driver's insurance adjuster is akin to speaking to the police without consulting your attorney first. It's never recommended. Number 6, don't accept quick settlement offers. Insurance companies often make settlement offers very quickly after an accident. sometimes within days. These offers might seem attractive to somebody when the insurance company is offering you money, especially when you're facing medical bills or you're missing work and you need the cash. But here's the problem. Once you accept the settlement and you sign a release, that's it. There are no do-overs. You can't come back later if your injuries turn out to be more serious than initially thought, if you've had more treatment than you expected just a few days after, if your symptoms get worse, have memory loss from a concussion, if your herniated discs manifest themselves and provide severe restrictions to your body, your physical limitations, if you're not able to work the same way and you lose the earning capacity that you once had before. There are several circumstances that could play out here. And I've seen insurance companies offer settlements to people who are still in the emergency room before they've even seen the full extent of their injuries. They know that many injuries take time to develop, and they want to close the claim before you realize how serious your injury really is. So take time to understand your injuries. Some conditions, like herniated discs, can take weeks or months to show their true impact. A traumatic brain injury can have effects that don't become apparent for months. You need to know what you're dealing with before you can make an informed decision about settling your case. Number 7, keep detailed records of how your injuries are impacting your everyday life. Your medical records will show what's wrong with you from a clinical standpoint, but they don't tell the full story of how your injuries have impacted your life. Insurance companies and juries need to understand the human side of your injuries, how they affect your ability to work, take care of your family, and just overall enjoy life. Start keeping a daily journal or some sort of notes from the day of your accident. Note your pain levels, what activities you can't do or are restricted from doing, how your sleep is affected, and any other ways your injuries impact your daily life. Are you unable to lift your children? Can't play golf anymore? Having trouble concentrating at work? Feeling soreness or pain while walking, sitting, getting up, driving? Document all of them. This isn't just about physical pain either. Many times, auto accident injuries can cause depression, anxiety, and other emotional consequences. The trauma of the accident itself can lead to PTSD. If you're having trouble driving or feeling anxious in cars, that's a legitimate consequence of your accident, and that should be documented as well. Also, keep receipts of any expenses related to your injuries, out-of-pocket costs that you've been required to pay, prescription medications, medical equipment, transportation to medical appointments, any modifications that you need to make to your home or your vehicle because of significant or catastrophic injuries. Number 8, understand the true value of your claim. When insurance companies make settlement offers, they often focus only on your medical bills and maybe some lost wages. But if you have a valid claim under Florida law, you may be entitled to much more than just your out-of-pocket expenses. Pain and suffering damages can be significant in injury cases. These are meant to compensate you for physical pain, emotional distress, and loss of enjoyment of your life caused by the injury. There's no formula for calculating pain and suffering. It depends on the severity of your injuries, how they've affected your life, and how long they're expected to last. You may also be entitled to compensation for future medical expenses if your injuries require ongoing treatment. If your injuries prevent you from working or limit your earning capacity, you could be entitled to lost future wages as well. If your injuries have caused permanent disability or disfigurement, additional damages may also be billable. Number 9, be aware of time limits. In Florida, you generally have 2 years from the date of your accident to file a personal injury lawsuit. This might seem like a long time, but it's really not. The sooner you begin the legal process, the better your chances of success. Evidence disappears, witnesses move away or forget details, and insurance companies become less cooperative as time passes on. So don't wait until you're feeling your best to think about your legal rights. The legal process can take a lot of time, and insurance companies are more likely to take your claim seriously if you have legal representation early in the process. Number 10, know when you need professional help. Not every auto accident requires an injury attorney, but many do. If you've suffered serious injuries, if there's a dispute about fault, if the insurance company is offering a settlement that doesn't seem fair, or if you're facing significant medical bills and lost wages, you should at least consult with an experienced personal injury attorney. Here's something important to understand as well. Insurance companies have teams of lawyers, adjusters, investigators, working to minimize the amount that they pay out. They have decades of experience handling these claims, and then or be tricked to reduce the value of your case. Shouldn't you have someone on your side who understands the law and knows how to deal with these companies? Most personal injury attorneys in Florida work on a contingency fee basis, meaning you don't pay any attorney's fees unless we, as your attorney, win your case. So this levels the playing field and allows injured people to have experienced legal representation without any upfront out-of-pocket costs. An experienced attorney can help you understand the true value of your claim, negotiate with insurance companies, and ensure that all deadlines are met. We can also help you find the right medical providers if you need ongoing treatment, and we can advance the cost of your case so you don't have to pay anything out of pocket. Number 11, don't let insurance companies rush you. Insurance companies want to settle your claim as quickly as possible, preferably before you hire an attorney. They'll often use tactics like telling you that you need to settle quickly or the offer will be withdrawn, or claiming that hiring an attorney will just delay your case and cost you more money in the end. Don't fall for these pressure tactics. A legitimate settlement offer should remain open for a reasonable period of time to allow you to make a reasonable and informed decision. If an insurance company is trying to rush you into a settlement, that's often a sign that they know your claim is worth more than they're offering. Remember, you have rights under Florida law. You have the right to understand your injuries fully, to seek appropriate medical treatment, and to be fairly compensated for your losses. Don't let anyone pressure you into making a decision before you're ready. Number 12, focus on your recovery while protecting your rights. Your primary focus should be on getting better. Follow your doctor's treatment plan, attend your medical appointments, and don't skip recommended therapies. Your recovery isn't just important for your health, it's also important for your case. But while you're focusing on your recovery, don't forget to protect your legal rights. Keep detailed records, be careful what you say to the insurance companies, and don't accept settlement offers without understanding their full implications. Remember, you didn't choose to be in this accident. You have rights, and you deserve fair compensation for your injuries and your losses. The steps I've outlined today will help protect those rights and put you in the best possible position for both physical and financial recovery. The most important thing to remember is that you don't have to navigate this process alone. The weeks and months following a serious auto accident can be overwhelming, but with the right approach and proper guidance, you can focus on what matters most, your recovery, while also ensuring that your legal rights are protected. Every case is unique, and the specific facts of your situation will determine the best course of action. But by following these steps and understanding your rights under Florida law, you'll be in a much better position to handle whatever comes next. If you found this information helpful, I encourage you to subscribe to our channel and hit that notification bell. We regularly share valuable insights about personal injury law in Florida that can help protect you and your loved ones. Take a moment to like this video and share it with your family and friends. You never know when someone important to you might need this information. These resources are designed to educate and empower you because an informed client is always in a better position to make decisions about their case. Thank you for watching, and I look forward to helping you understand your rights and options under Florida law. See you over there.